Judgment in the appeal, Aberdeen City and Shire Development Planning Authority.
Lord Hodge will give the judgment of the court.
This appeal raises a question as to whether and in what circumstances a planning authority in Scotland has power under existing planning legislation to require developers to enter into planning obligations by which they make financial contributions to a pooled strategic infrastructure fund. The Appellant Planning Authority produced a strategic development plan in which it identified 4 strategic growth areas in the vicinity of Aberdeen. In the supplementary guidance to that plan, the authority provided for a strategic transport fund to deliver the infrastructure which it had been advised was needed to accommodate all of the development in those growth areas for which it planned. The supplementary guidance envisaged that developers would enter into planning obligations under the Town and Country Planning Scotland Act 1997, under which they would make phased contributions to the fund as they developed their sites. The contributions were to be pooled and would be available to contribute to the cost of the planned infrastructure for the 4 growth areas. The Respondent company is a developer which proposes to build a substantial residential development in one of those growth areas. It challenged the legality of the fund on the basis that it was contrary to the guidance of the Scottish ministers in a circular on planning obligations because it claimed that the contributions required of it were disproportionate to the impact of its development on the existing transport infrastructure. The Respondent entered into a planning agreement under Section 75 of the 1997 Act with Aberdeenshire Council, in which it undertook to pay the specified contributions, but only on the basis that it would not pay those contributions if the guidance were held to be invalid. The Respondent challenged the validity of the planning guidance in an appeal in the Court of Session. The inner house of the Court of Session quashed the supplementary guidance on the basis that the obligation to contribute to the fund breached the Scottish Minister's circular, which required that planning obligations must fairly and reasonably relate to the permitted development. The Planning Authority appeals to this court on the basis that the policy tests in the circular were not legal tests for the validity of the planning obligation. This court unanimously dismisses the appeal. The scheme for contributions involved the pooling of payments which were not tied to a particular development, and the scheme was not lawful under the 1997 Act for 2 reasons. First, the use of the developer's contribution in a pooled fund with which its development had no more than a trivial connection means that the planning obligation is not imposed for a purpose related to the development and use of the site, which is burdened by the obligation, nor does the planning obligation restrict or regulate the development of the site, as Section 75 of the 1997 Act requires. Secondly, and separately, the planning obligation which the Respondent entered into was an irrelevant consideration when the local planning authority came to consider the Respondent's application for planning permission, because there was only a trivial connection between the proposed development and the infrastructure interventions which the contributions would fund. When a developer applies for planning permission, a planning authority currently does not have power to require it as a precondition of grant of permission to enter into an obligation which would be irrelevant to its application. In reaching this view, the court examines first the rules governing the lawfulness of a planning condition, secondly, the rules governing the lawfulness of a planning obligation, thirdly, the role of the planning obligation in the grant and refusal of a planning permission, and fourthly, the boundary between questions of legality and questions of policy. The scheme wasn't unlawful because it did not comply with the Minister's circular, which was only a relevant consideration to be taken into account, but not necessarily followed in making of the planning condition. It was unlawful for the 2 reasons which I have given. The court recognises that there is much to be said in favour of such a scheme as the Strategic Development Planning Authority had sought to implement, but there will need to be legislation to bring in such a scheme as there has been in England and Wales.